welcome to the University of Montana and to the Montana Law Review's 12th Browning Distinguished Lecture in Law. I'm Anthony Johnstone, and I have the privilege of serving as the advisor to the Law Review, which I count as the second best job I've ever had, next to working for tonight's distinguished lecturer. Tonight, we also celebrate the Law Review's 75th year of publication. 75 years ago, our students made a lasting gift to Montana and the legal community by founding the Montana Law Review. Now, in 1940, there were only about 50 flagship law reviews. There are now 206. By one count, the Montana Law Review is the 10th oldest law review west of the Mississippi, the third oldest in the Rocky Mountain West. It has a great and distinguished history. And over those 75 years, the Montana Law Review has grown from the most important scholarly journal chronicling and evaluating developments in Montana law between its covers to a new model of engaged scholarship featuring both traditional article-length treatments of issues of importance to Montana, as well as new online shorts, coverage of Montana Supreme Court oral arguments, and even tweets, a Twitter feed. You can tell I don't have an account. I do, I don't use it. A Twitter feed of Montana decisions. This year, the Law Review's editors and staff produced as much online content as would fill a third issue in their volumes, over 100 pages of online content, in addition to maintaining the great tradition of the print edition. This work has impact all the way up to the Montana Supreme Court and beyond. We have it on good word that several Montana Supreme Court justices have the website on their reading lists. I'd like to begin, before turning to the lecture, to just recognize our incredible students for their hard work, the staff and editors of the Montana Law Review. Please stand. Now to turn to tonight's Browning Lecture, featuring the Honorable Sidney Thomas, Chief Judge of the United States Court of Appeals for the Ninth Circuit. First, I'd like to turn to my colleague, Professor Hilary Wandler, to introduce the lecture series. Professor Wandler is a graduate of the School of Law in 2004, and to all of our delight and to the students' gratitude, returned here to teach in 2008. Professor Wandler.
Hello, my name is Hilary Wandler, and I had the distinct privilege of clerking for Judge Browning after I graduated from the University of Montana School of Law. I was going to tell you some of the high points of his career, but I believe that Judge Thomas is going to go through some of those things for you. He was an innovator in both the court system and as a litigator, and I'm excited for you to hear some of those stories because they are so great, and they're endless, really. I'll just tell you that I think Judge Browning demonstrated the character that we should all aspire to. The character of a Montana man. He was built from the solid foundation of a Montana-made legal education, like many of you will be. He was consistent in his integrity, in his professionalism. He demonstrated the power of nice. If you've ever seen that book, I think actually Judge Browning may have invented that. And if you sprinkle in a little bit of being in the right place at the right time, a lot of the time in his career, you get a person who really was wholly admirable, as Justice Jackson of the U.S. Supreme Court said. And we honor him with this lecture because of the man he was, the litigator he was, the court administrator he was, the judge he was. I believe we're in the 12th lecture. I can't see Anthony now. And I hope I remembered that correctly. We're in the 12th lecture, and each one has really demonstrated through the many stories of his career what an amazing individual he was. So welcome, and I hope you enjoy the stories about his career from Judge Thomas. Thank you.
To introduce Judge Thomas, I will introduce Judge Donald Malloy, another one of our own, graduated from the School of Law in 1976 and after a distinguished career in practice, was commissioned to the U.S. District Court in 1996, the same year that Judge Thomas took the bench. I'd like to add a special note of thanks to Judge Malloy and all of the attorneys who serve on the Federal Attorney Admissions Fund for their longstanding support of the School of Law and the Montana Law Review in particular, and specifically their significant support for renewing and continuing this important Browning lecture series. Judge Malloy.
Thank you, Anthony. I should be able to do this without notes, but Eddie and Tom told me that I only had a limited time, so I found that the way I can limit my time is to have notes, and I don't keep going. Just as an aside, when I clerked for Judge Batten in 1976, in the summer, there was a little guy that would always come up to Billings because his wife was from Belfry, and he drove a Renault, and he was the nicest guy. It was Judge Browning. And I got to know him there, and then really fortunately got to know him before he passed on as a fellow member of the bench. But for purposes of tonight, it really is an honor and a privilege for me to introduce Chief Judge Sid Thomas of the Ninth Circuit Court of Appeals. As Anthony said, I've known Sid since law school, and in nearly 20 years as a lawyer in Billings, I had the privilege to do battle with him on many occasions when we were both practicing attorneys. During those cases, I always thought that Sid was on the wrong side, but too often he was right. I have continued to have that same experience since he's been on the Court of Appeals. But there was one thing about Sid, and is something about him. He always seems to get it right, and to do so in a reasoned and articulate way. I know that he empathizes with the district judges of the Ninth Circuit because on one occasion he served as a trial judge in Montana. And after the verdict, the case went up on appeal, and of course his colleagues reversed him. And I remember asking Sid what he thought about the experience, and he immediately articulated the lament of the district judge who has been reversed. They weren't looking at the same case I was. He is the third judge from Montana to become the chief judge of the largest circuit in the nation. The Ninth Circuit deals with more cases than the combined caseload of many of the other circuits. It does not take long in spending time with Chief Judge Thomas to know that he is a leader. He is a wonderful human being, and he is a judge that was shortlisted by President Obama to fill the seat on the United States Supreme Court now occupied by Justice Elena Kagan. Now, leadership is not a characteristic that comes easily, nor does it usually come naturally. I note that Judge Browning fit that bill very well, and so too does Chief Judge Sid Thomas. I remember when I first came on the bench, when Judge Paul Hatfield was around, he described the role of the chief judge as one where you try to herd chickens with a cattle prod. Some other judge described the chief judge's position, particularly at the Ninth Circuit, as being akin to the caretaker of a cemetery. There are a lot of people under you, but nobody listens. But I don't think that's going to be the case with Judge Thomas. I think he is a leader, and I want to just make some brief comments about him as a leader, not only in the community, but also on the bench. It's been said that before a leader can come first, he has to come forth. And Chief Judge Thomas showed leadership skills even before he matriculated to Montana State University, where he obtained his bachelor's degree in 1975 in speech communication. As an undergraduate, he was a recipient of the Dean's Honor Scholarship and other academic awards. He attended law school at this university, and as a law student, he was not only involved in the academic aspects of the study of law, including serving as a teaching assistant, but amazingly, he graduated cum laude while at the same time serving consecutive terms on the Montana Board of Regents. The Board of Regents was only the beginning for Sid. He served on the board of the Montana Legal Services. He's been on the board of Public Radio, KEMC in Billings. He was the director and president of the Alberta Bear Theatre. He served as a director in the I Am Third Foundation, and importantly, he served as the chair in Billings of the St. Vincent's Hospital and Health Center. That position involved working closely with the medical staff and other members of the St. Vincent's Hospital Board. And I have some insight as to what might have been involved, because I know members of that board who served at the time that Sid was there, all of whom marveled at Sid's ability to listen to the cacophony of views, arguments, and perspectives, and then be able to summarize issues and suggest meaningful solutions to the myriad problems confronting the board. In addition to his remarkable commitment to public service, Sid was a leader and a shareholder of Moulton Bellingham, Longo and Mather. As a lawyer, he earned a solid reputation not only as a litigator and a trial lawyer, but also as a constitutional scholar who was particularly adept at questions that involved the First Amendment. He was an early activist in political matters. He also served on the faculty of Rocky Mountain College. In my view and in my experience, he exemplified what it means to be an attorney and counselor. He always displayed the highest ethics in every undertaking. He is always and was always courteous to the litigants and still is. His word was his bond, and he always did the right thing by the law and the facts. And in any case that he handled, it seemed to me that, and even having had the pleasure of sitting with him on the Ninth Circuit, he isn't somebody who just seeks an answer or to win, but he's somebody that understands and understood as a lawyer the idea of justice. I think he was a lawyer's lawyer, and I know he is a judge's judge. On July 19th of 1995, President Clinton nominated Sid to replace Judge Dorothy Nelson as she assumed senior status. The nomination was a perfect hand-in-glove fit for later taking over the Chief Judge's role, which was exemplified by Chief Judge Browning. Judge Thomas received his commission on January 4th, 1996. He has served for many years as the Ninth Circuit en banc coordinator, and he has done so in his typical even-handed fashion. He's made significant contributions to the court's handling of death penalty cases, and has done so with intelligence and dignity. And as I said, remarkably, he is the third Montanan to serve as the Chief Judge of the Ninth Circuit. And I can tell you that he has the respect not only of his colleagues on the Ninth Circuit, but he has the respect of the district judges, and all of us are looking forward to his leadership. He's an unassuming man, a man with a wonderful wit and a great sense of humor. He's a listener, and that makes him a good leader. He's married to Martha Sheehy, which is likely another reason he's a good listener. I love that laugh. They have two sons, Oscar and Skeff, and I'm sure Chief Judge Thomas probably has multiple diamond-level benefits for all the traveling he does on behalf of the court and its constituents. He's an avid San Francisco Giants fan, along with his son Skeff, and an engaged intellect with his son Oscar. Now, I know that years ago, President John F. Kennedy told the story about the leader of the French Revolution, and the way Kennedy told it was, the leader said, "There go my people. I must find out where they're going so I can lead them." With Chief Judge Sid Thomas, I'm sure we will be saying, "There goes Sid. I know where he's going, and I'm going to follow." Ladies and gentlemen, we are fortunate to have Judge Thomas give this Browning lecture. It's my pleasure to introduce my good friend, Chief Judge Sidney Thomas.
I want to thank Judge Malloy for those kind remarks. My father would have appreciated. My mother might have offered a rebuttal. And I want to compliment Judge Malloy. I don't think you probably understand here in Missoula what impact that Don has made on the Ninth Circuit and the national federal judiciary. He has contributed in so many ways, on so many committees. He's been tireless. And I can tell you from looking at his work from afar, how much he transformed this district by his leadership as Chief Judge. And would you join me in giving applause to Chief Judge? I also want to introduce a member of our Ninth Circuit staff who by happy coincidence is here today, Claudia Bernard. Claudia, would you stand, please? Claudia is our Chief Circuit Mediator. The Ninth Circuit Mediation Office is the most successful in the federal judiciary. They settle about 1,000 cases a year. That exceeds the output of the D.C. Circuit in its entirety. So we thank you very much, Claudia, for your tremendous work. Now on to Judge Browning. You really cannot find a single person who didn't like Judge Browning. You can't find a single person who did not deeply respect him. It's simply impossible. So on the 75th anniversary of the founding of the Montana Law Review and the lecture that bears its name, it's appropriate for us to consider the life and legacy of Judge James R. Browning, the nation's longest-serving circuit judge. I first met Judge Browning at this law school when I was graduating, and he was getting an honorary degree. He was a relatively newly minted chief judge of the circuit and impressive at the time. And over the years, as Judge Malloy did, I saw him from time to time in Billings when he'd make his annual summer pilgrimage. After my own appointment to the bench in 1996, he greeted me with a big bear hug and the University of Montana fight song saying, "Up with Montana." And I was privileged to serve with him on the court for a decade and a half, and I'm proud, as many of us are here today, to call him a dear friend. He started his life, as he lived his life, modestly. He grew up in Belt, approximately a population of 500, son of a blacksmith. His grandfather had emigrated from Ireland to find work in the mines. His family tells me that from those days they still own an ownership interest in a silver mine, but unfortunately it's now a Superfund site. He was a promising debater for the Belt Mustangs. It was during forensics competition that he met his future wife, Marie Rose, who lived in the similarly sized town of Belfry. Belt and Marie Rose led him to the University of Montana. At that time, he was under the 5-year plan, whereby he could finish his undergraduate work and his law studies in a combined 5 years. And there's a South Hall yearbook of that period. There's a cartoon in it of Judge Browning showing him perched over a desk studying by lamplight. The cartoons of his fellow students portray them in, say, different lights, more lively poses. He enrolled in this law school, although, as his family told me, he'd probably never even met a lawyer. And yet, as you know, he excelled in his studies. He co-founded the Law Review, served as its editor-in-chief. His first Law Review article posed the riveting questions, must attesting witnesses be able to see the testator's signature? But he loved the University of Montana Law School. Years later, when former clerk and now district court Ed Chen asked him about his life's highlights, he recounted a few of the famous episodes of his life, but then he recalled with particular, and what the clerk thought was very unusual pleasure, that he was the only student in his demanding evidence class who could describe the difference between a document used to refresh recollection and a past recollection recorded. Now, that evidence professor was the Honorable Russell Smith, who later wrote that Judge Browning was the best student he'd ever seen. And that, by the way, is a past recollection recorded. He was first in his class, receiving A's in every single class, but on graduation, his future looked bleak. He simply could not find a job in Montana. His only job offer was to work part-time, briefing water law cases for the Montana Supreme Court. And so he said, I looked at my report card with all A's, but I had no prospects. So at the suggestion of Professor David Mason, he took a job with the Department of Justice Antitrust Division in Denver. The irony, of course, is that University of Montana School of Law didn't teach antitrust law. He said, I didn't know anything about antitrust law. I didn't know what antitrust was, he said. But he soon rose to become one of the nation's leading experts in antitrust law. His career was put on hold 2 years later upon his induction into the United States Army, and his talent was recognized, and he was pulled off a transport ship that was bound for taking Army troops to invade the Pacific Islands and transferred to military intelligence. It was one of many of the fortuitous events of his life. He rose to the level of first lieutenant and was awarded the Bronze Star. And it was during this period that he met another young attorney, Byron White. I got to know Justice White years later, and when I sat with Justice White in San Francisco, it was just fascinating to hear Justice White and Judge Browning exchanging not only war stories, but remembrances about the civil rights battles of the 1960s. Judge Browning then returned to the Department of Justice, first in Washington, then to Seattle to head up the department's regional office. He returned to Washington to become assistant chief of the general litigation section of the Antitrust Division, first assistant of the Civil Division, and then executive assistant to the Attorney General. And as executive assistant, he formed the Executive Office for U.S. Attorneys, which is still a very powerful arm of the Department of Justice. He became first chief of that office. He had a large hand in the Department of Justice litigation before the Supreme Court during that period. He sat at counsel table as the Solicitor General argued for 5 hours in the historic Youngstown Sheet and Tube Company versus Sawyer appeal. Youngstown Sheet, as you may recall, involved President Truman's seizure of the steel manufacturing plants on the eve of a nationwide strike so the plants could stay in production. And the Supreme Court held that the President had exceeded his constitutional authority. You may recall about the case that President Truman was just stunned by the decision that caused a great rift between the White House and the Supreme Court. And it began to take a fever pitch, fearing a reaction similar to the one that President Roosevelt had had, and with the ensuing court packing plan. The author of the opinion, Hugo Black, invited all the members of the court and the President over to his house for a social gathering. Truman reluctantly went, but during the course of the evening became somewhat mollified, and by the end of the evening he said, Hugo, I don't care much for your law, but by golly, I do like your bourbon. And Judge Browning was a key figure in that litigation. He also had a strong influence on the department's position in Brown versus Board of Education. The Department of Justice under Attorney General Tom Clark during the Truman administration had filed supporting briefs in a number of cases condemning discrimination and segregation, including Shelley versus Kramer, Henderson versus the United States, McLaren versus Oklahoma State Regents, and Sweat versus Painter, just to name a few. But when it came to Brown versus the Board of Education, under a different Attorney General, the Justice Department balked. Solicitor General Philip Perlman was adamant. He said, it's much too early to end segregation in the public schools. You can't have little black boys sitting next to little white girls. The country is not ready for that, he said. The line had to be drawn. Trains, dining cars, law schools, graduate schools, yes, but not the public schools. In short, unbeknownst to anyone, the Department of Justice had decided to change its position on segregation and discrimination. But then a series of fortuitous events occurred. Amidst the scandal, the then Attorney General Howard McGrath was forced to resign, and James P. McGranery, an old friend of Truman's, was appointed Attorney General. Now, McGranery was, by all accounts, extremely eccentric and unstable, completely off his rocker, according to one DOJ insider at the time. But he particularly despised the Solicitor General. So the Solicitor General quickly left the Department of Justice, and the attorneys who had tried to persuade the Solicitor General to write a brief in Brown versus Board of Education went to see the Attorney General to pitch the idea of filing a brief. They didn't pitch it on the merits. They pitched it on the notion that it would really, really serve the Solicitor General right if the Attorney General changed his position. And the Attorney General, who was absolutely despised the Solicitor General, was happy to countermand any decision he made, and he agreed to it. But the attorneys feared that the Attorney General, once he understood what he did, might change his mind, and there was no telling what the new Solicitor General was going to do. And time was of the essence. It looked as though the entire endeavor might be derailed. But the Attorney General's executive assistant at that time was none other than our own Jim Browning. And the attorneys who had written the brief came to him and explained their dilemma. And he said, I don't see any reason to trouble the Attorney General with this issue. I don't see any reason to wait for the new solicitor. You just send the brief into the printers under the Attorney General's name and yours, and just leave it to me if anyone objects. And so that was how the Department of Justice filed a brief in Brown versus Board of Education in support of desegregating the public schools. And the attorneys who were involved in that readily acknowledged that without Judge Browning's support during the entire endeavor, and particularly during that critical period, the Department of Justice would have never injected itself into the case in the first place, or worse, would have taken a different position. And it was in that brief that filed by the Department of Justice that a suggestion was made to declare segregation unconstitutional, but to afford district courts time to implement the decision with all deliberate speed. Of course, that's the standard that ended up in the decision. In 1952, he argued his first case in front of the United States Supreme Court in his capacity as special assistant to the Attorney General. He won, and his brief is a model of persuasion and succinctness. Later in life, his nephew would recount an evening up here in Missoula in which some family members played a two-piano Mozart sonata at a family gathering. When asked what he thought of it, Judge Browning sighed and said, I wish I could write a brief like that. And after reviewing his work in that case and others around that period, I can assure you that he did. It shows that he lived, and those briefs shows he lived by the advice he later gave his law clerks to never use two words when one would suffice. He left the Department of Justice to go into private practice, somewhat ironically with the former Solicitor General, and continued to argue before the United States Supreme Court, appearing in numerous cases. He also taught at Georgetown and New York University in antitrust law. Chief Justice Earl Warren began asking him to appear pro bono for indigent defendants, which he did. He appeared pro bono in the first Mann Act case, successfully representing the indigent defendant. After one argument, Felix Frankfurter said to his colleagues, that Jim Browning must have been a Harvard man. After another, Justice Jackson wrote Judge Browning saying, your presentation was wholly admirable, and I'm not alone in so thinking. Well, that pro bono work, along with his advocacy, impressed Chief Justice Warren, and in 1958 he called up Judge Browning out of the blue and asked him to be clerk of the United States Supreme Court. The only downside of the position, as Judge Browning later recounted, was he was forced to wear the uniform of the High Court clerk, which was tails and striped trousers. Here I was from Belt, Montana, appearing in this regalia every day, he said. That appointment, of course, led to one of Judge Browning's most famous moments when he held the Bible at the inauguration of President John F. Kennedy, with his picture appearing in all the news magazines and major newspapers. Characteristically, he noted that his job that day was simple, but he was also aware that his predecessor seemed to scowl during President Eisenhower's inauguration, and that the court had later received a number of complaints about it. So I tried to look agreeable, he said. He was the last clerk of court to hold the Bible, that task having been assumed by the spouse of the president-elect ever since. During his tenure as clerk of the Supreme Court, he reorganized the office and took significant steps to archive significant historical documents, a task that had never been undertaken. He found water-stained briefs written by Abraham Lincoln as a lawyer and saved them. And he initiated a major program to preserve the Supreme Court records. He toured the country giving presentations to bar exams, urging the importance of maintaining historical records. Well, it was during that time period that Judge Walter Pope of Montana decided to take senior status, creating a vacancy on the Ninth Circuit Court of Appeals. Senator Lee Metcalf, a neighbor and close friend of Judge Browning's, urged that Judge Browning be appointed. Senate Majority Leader Mike Mansfield favored Professor Russell Smith of Missoula. Attorney General Robert F. Kennedy consulted with an old friend, a consummate Washington insider who hailed from Butte, James Rowe. And Rowe, as you may remember, was a key advisor, part of the Brain Trust during the Roosevelt administration. And he advocated for Judge Browning's appointment, saying that both of these men would make competent judges and are quite superior to the present composition of the Ninth Circuit bench, which is not saying very much. In my view, Browning is superior because he has been steeped in appellate practice, as few men in the nation have been. Ironically, one of Roe's concerns was that the Ninth Circuit was not only weak, but a conservative bench quite out of step with the premises of the New Frontier. We were too conservative back in 1960. Judge Browning's nomination was fraught with controversy. Justice Felix Frankfurter strongly opposed it. He apparently had discovered that Jim Browning was not a Harvard man. He did not believe anybody from the University of Montana was qualified to sit on the Court of Appeals. The ABA gave him a not qualified rating, mostly because he had not practiced in Montana. And there was opposition in Montana for the same reason. But Justice William O. Douglas, a Columbia and Yale man, strongly supported his candidacy, and Professor Russell Smith strongly defended him back in Montana. He was nominated and confirmed in 1961, and 5 years later, as we all know, Russell Smith was appointed to the Federal District Court of Montana by President Lyndon Johnson. Judge Smith and Judge Browning remain lifelong close friends. On the Ninth Circuit, Judge Browning immediately hit his mark. He quickly endeared himself to his new colleagues, and he had tea with his predecessor, Walter Pope, every afternoon at 2 o'clock. As you might expect, given his background, he immediately commenced what scholars have termed extraordinary work in the field of antitrust law. As he said, I was raised in the era of trust busting, and his antitrust jurisprudence certainly reflects that philosophy, with opinions such as Lessig versus Tidewater Oil in 1964, Greyhound Computer versus IBM in 1977, Digidyne versus Datagen in 1984, and his dissent in GTE Sylvania versus Continental TV. He established himself as one of the nation's leading thinkers in antitrust law. He was consistently concerned with the predicament of small businesses as they sought to compete and secure a place in the market. He said to me once he was never doctrinaire about any legal issue, but then he added with a twinkle in his eye, except maybe antitrust law. Although his specialty was antitrust law, he left an indelible mark on national jurisprudence in other areas as well. One of his first decisions on the bench, he authored an opinion, the first opinion in the nation, expressing the point of view that a criminal defendant not only had the right to counsel, but the right to competent counsel. In Brubaker versus Dixon, issued in 1962, it was the first federal case overturning a conviction for ineffectiveness of counsel. In that case, Judge Browning held that a trial in which a defendant's counsel ignored obvious defenses would not constitute a fair trial under the Due Process Clause. And 16 years later, in Cooper versus Fitzharris, he suggested a standard for ineffectiveness of counsel that was later adopted in large part by the Supreme Court in Strickland versus Washington. Judge Browning's powerful dissent in Smeda versus United States in 1966 proved the foundation a year later for the Supreme Court's seminal Fourth Amendment decision in Katz versus the United States. Judge Browning wrote that the Fourth Amendment protects such privacy as a reasonable person would suppose to exist in given circumstances. Now, you may recall that Katz's most famous language stated, the Fourth Amendment protects people, not places. What a person knowingly exposes to the public, even in his own home or office, is not the subject of Fourth Amendment protection. But when he seeks to preserve as private, even in an area accessible to the public, must be constitutionally protected. Now, at the conclusion of that passage in its original draft, Justice Powder Stewart cited Judge Browning's language, quoted it, and cited his dissent. The citation did not appear in the final opinion, but his influence on the development of Fourth Amendment law in Katz is clear. One of the most remarkable things about the Smeda case, it was one of the first cases that involved the assertion of gay rights. The case was intended, in fact, to be a pioneering effort to use the law to protect the rights of gays under the Fourth Amendment and the right of privacy. The case was enormously controversial at the time, and Judge Browning's dissent forcefully argued for Fourth Amendment protection. In Corsican Productions versus Pitchness, he held that the producers of a film that was labeled obscene had First Amendment rights, a decision that presaged later decisions by the Supreme Court. He knew a First Amendment problem when he saw it. And similarly, in United States versus Brooklier, he held that orders barring the media and public from certain portions of a trial must articulate clear reasons for closing a courtroom. As my colleague, Judge Marcia Berzon, and former Browning clerk has observed, his jurisprudence has a theme of allowing access to the courts, whether by litigants, the press, or the public. And he was never one to tout his own opinions. On our court, he was known as Mr. Per Curiam because he insisted on many occasions of issuing per curiam opinions. I asked him about that one time, and he said, authoring a decision is an act of ego. We should be speaking as an institution. And he once sent a memo to his colleagues entitled, On Judicial Modesty, Immodesty, and Per Curiam Opinions. By the late 1960s, it was widely assumed that if Hubert Humphrey had defeated Richard Nixon for the presidency, that Judge Browning would be elevated to the Supreme Court. Sadly, that opportunity did not occur, but the Supreme Court's loss was our gain, because his greatest national legacy was as Chief Judge of the vast Ninth Circuit, which covers an area larger than the Roman Empire. As he often observed, it stretches from Guam to Glendive, and I don't recommend that drive to anyone. There really is no other way to put it. Judge Browning was unquestionably one of the best Chief Circuit judges in our nation's history. He virtually invented the modern federal judiciary. As he said to me, I didn't covet the job as chief, I didn't seek it, but once it fell to me, I loved it. When he assumed the role of chief, he faced some serious obstacles. When he had joined the court in 1961, it had 443 cases. That had risen to 3,000 by the time that he took over as chief. Modest by our standards, but still an enormous increase. And the Ninth Circuit needed judges. But there was a large national debate about splitting the Fifth Circuit and the Ninth Circuit, mostly because of the political problems, the controversies of the Fifth Circuit. A commission was formed to study the issue, and in the end, almost solely due to the work of Judge Browning, the Ninth Circuit obtained its judgeships, and both circuits were allowed to determine their own destiny. After a 4.5-hour en banc session, the judges of the Fifth Circuit quickly decided it should divide, and Congress quickly acceded. But the Ninth Circuit decided to stay intact, and Judge Browning was confronted with the question of how to run a large circuit. He immediately devoted himself to that task, creating an enduring structure by which a large circuit could operate effectively. To avoid the problems confronted by the Fifth Circuit, he developed the concept of a limited en banc court of 11 judges rather than the full court. And though many people doubted that that would work, it has met the test of time. The decisions of the limited en banc court have been accepted as authoritative, and the judges on our court have been satisfied that it has sufficient representation. To address the issues of administration, Judge Browning established administrative units to deal with particular issues in specific geographic areas. And even though he was a lifelong computer illiterate, he aggressively pushed for the use of technology for the courts. He developed the first electronic docketing system in the federal courts and the first email system. And as I recall many years ago when Judge Malloy and I were down in San Francisco taking depositions, we visited his friend and classmate Bob Lon, and Bob Lon was working for Judge Browning at the time. He told us he was working on an electronic mail program. And we said, electronic mail? What is that? This was the late 70s, early 80s, even before faxes had become in popular use. But he resolutely refused to use a computer, never learned how to do it, which it sat behind his desk largely as an ornamental object. But he understood the importance of technology in the future of the courts. And to the end, he edited his opinions by literally cutting and pasting. He would snip with the scissors, and he would then tape them on and then have the opinions typed up. Until Judge Browning changed it, attorneys were not permitted at the circuit conferences. He thought it was important and necessary that they be included, and the Ninth Circuit became the first circuit to have a conference that included both lawyer representatives and judges. He believed strongly that the governance of a circuit should be shared between the circuit judges and district judges, and the Ninth Circuit became the first circuit to have equal representation of both on the Judicial Council. His model was later adopted by the entire nation. He understood that the national judiciary needed to develop a system to manage judicial misconduct, and he was instrumental in national legislation on the subject and in establishing our modern system of judicial discipline. He created the Staff Attorney's Office, which allowed the processing of non-controversial cases controlled by precedent to proceed without oral argument, which reduced case processing time significantly. That vision later translated in the creation of the first and only Office of the Appellate Commissioner to handle routine motions, settle fee disputes, handle appellate vouchers, administer attorney discipline, and hold Feretta hearings. He came into the office of the Ninth Circuit having a large backlog of cases and reduced the backlog by half when he left. He established the Circuit Court mediation system, and with Dorothy Nelson followed the Western Justice Center, which is dedicated to the peaceful resolution of disputes through mediation and other means. He believed in specialty courts were appropriate, and to that end he founded the Bankruptcy Appellate Panel, a creation that has been enormously successful in our circuit, resolving thousands of cases. He created an executive committee of the courts so routine administrative decisions could be made quickly without having to wait for a court meeting, and recognizing the need for federal and state cooperation, founded federal and state judicial councils throughout the Ninth Circuit. Mindful of his experience in the Supreme Court when he discovered those water-damaged briefs of Abraham Lincoln, he founded the Ninth Circuit Historical Society to preserve the history of the Ninth Circuit. But perhaps his greatest accomplishment was keeping the circuit together all those years against countless challenges. He worked tirelessly through the halls of Congress, toured the circuit, making his case that our circuit was best kept together. And he continued that effort long after he stepped down as chief. The list could go on and on. But I have to say, maybe perhaps his most important legacy as chief was his cheerful ability to persuade his colleagues. And he did so with intelligence, warmth, humor, and persistence. He once gave a speech entitled, "It's a Long Way to Heaven," with the subtitle, "But it would be a lot shorter for my colleagues if they accepted my good ideas." Former Chief Judge Proctor Hugg, who was a wonderful chief in his own right, observed, "As Chief Judge, he was a marvel of administrative skill. I was always intrigued by the way that he succeeded in leading the way, the very independent-minded judges of this court to adopt his ideas. A matter would be brought up at a court meeting and be received with objections and utter lack of enthusiasm. The next meeting, the matter would appear again in a little different way and would be received with more enthusiasm. And at the third meeting, we brought up with further modifications, and lo and behold, it would be adopted unanimously. And we'd all wonder, how did he do that?" Justice Anthony Kennedy, who has a fondness for Montana, either because of or in spite of his summer working the oil fields near Glendive, recalled that I would storm into his office with about some administrative matter or maybe a case, and he would listen carefully and say, "Well, we can talk about that, or we can solve that," and that would be the end of it. He was truly a genius at court administration. Former Chief Judge Schroeder commented he is among the most resilient, the most cheerful, and the most determined of mortals. And I personally do not recall a single conversation with him unless we were talking about something of some very serious matter. At some point, he did not clap his hands and laugh. Most of all, he sought to preserve harmony. As he said, "A chief judge tends to take a neutral point of view. I've not cast a vote one way or the other to keep the peace, but this 12 years has convinced me that the court can do its best work if it works in harmony, and I will continue to work for that no matter what. There is not a position or issue that seems to me of comparable importance." The longer he was on the bench, he said, the more you see that there is ground on which everyone really can walk, and the extremes become less interesting or necessary. He'd often say, "When you receive an annoying memo and can craft a perfect, clever, sarcastic, and utterly deflating response, don't send it." At the end of Judge Browning's term as Chief Judge, Chief Justice Warren Burger praised him as a court administrator combining the skills of Soviet leader Mikhail Gorbachev and symphony conductor Arturo Toscanini. He received the Devitt Award, which is essentially the judiciary's Nobel Prize for Judicial Administration, and the American Judicature's highest prestigious award, the Herbert Harley Award. And after years of effort, Congress passed legislation naming the courthouse in San Francisco, our circuit headquarters, the crown jewel of our circuit, after Judge Browning. He had much support for that from Senators Orrin Hatch, from Senator Barbara Boxer, from Senator Feinstein, from Speaker Pelosi, and of course our own Senator Max Baucus. Senator Orrin Hatch wrote, "Judge Browning has the respect and strong support of judges and lawyers from all over the West." Carolyn Kennedy, who wrote to honor his 50th year of service and his service as the longest-serving Kennedy appointee, said, after detailing his accomplishments, "You were able to accomplish these many Herculean tasks because you are an exceptional leader. Your colleagues in the court comment that you taught them that even if they disagreed, they could do so agreeably. And that theme continues to this day. Your leadership as Chief Judge of the Ninth Circuit has left an indelible mark on the burgeoning communities of the Ninth Circuit, from the Pacific Rim to the Sea of Tokyo and north to Alaska. We celebrated the centennial of that courthouse and its renaming for Judge Browning about a decade ago. Speaker Pelosi and Senator Baucus, other dignitaries, attended. And on that occasion, Senator Baucus said, "Judge Browning's career has been, in the words of the inauguration in which he held the Bible, a celebration of freedom. Mosaics of tile ornament the floors of this fine building. Granite adorns its walls, and stained glass colors its skylights. But the thing that most graces this building is that Judge Browning's chambers are here." On that occasion, I asked Judge Browning if there's anything we do back in Montana to add to the celebration, and he said, "Well, maybe a little piece in the Butte or the Belt newspaper to let my relatives know that I turned out okay." He continued serving and strongly contributing to the court until his death. He was the longest serving federal court of appeals judge in our nation's history. So what's his legacy? For his personal legacy to his clerks and the court family, it was quintessentially judicial modesty, as his former clerk, Judge Ed Shen, noted. That modesty shouldn't be mistaken for reticence because he was really tough as nails, but he had true judicial modesty. In his expansive chamber suite, he picked the smallest room for his personal use. In every endeavor, he put the court first and his ego second. He made every clerk feel as though they were members of his family. As one clerk remembered, even when he was shredding your draft opinion, he made you feel as though you were the next Louis Brandeis. And he was kind to everybody. To the worry of the Marshal's Service, he would greet all of the homeless people around the federal courthouse with hi friend, every day, becoming on first name basis with many of them. And he always greeted me with the cheery, "Up with Montana," and raised his arm. As to the legacy on our court and the federal judiciary, the structure and the innovations he put in place have met the test of time. We're faced with challenging budget times, and courts all over the nation are asked to do more with less, to consolidate and share administrative services. These are concepts that Judge Browning lived by as chief, concepts that the rest of the judiciary is just now coming to. He proved that a large circuit court could work effectively and efficiently. When I joined the court, although we had the same number of judges as when Judge Browning was chief, the caseload had tripled from 3,000 to 10,000 and finally reached 16,000. But we were able to manage it largely through the structure that he invented. On our court, the staff attorney's office, he started and shared with the judges, resolves thousands of cases every year. Oral screening panels resolved 2,400 appeals last year, written screening panels, almost 500 motions panels, 3,500 certificate of appealability panels, 1,000, almost 2,000 cases. The clerk's office procedural motions unit resolved 5,000 case motions last year. The appellate commissioner resolved over 1,000 motions. And as I mentioned, our fine mediators settled nearly 1,000 cases last year. And all of those allow us as judges to judge instead of being consumed with administrative matters and non-controversial issues. We continue to be a leader in technology, recently adding high-definition streaming of court arguments, a superior filing system, and a nationally recognized website. His design of misconduct systems met the test of time. And all these innovations came directly or indirectly from Judge Browning. And what's his legacy for Montana and the law school? He probably articulated his vision best in a speech before the Montana State Bar in 1972, which bore the existential title of "Why Are We Here?" As to law schools, he quoted Dean Gordon Christensen in saying, "Law schools are the place where our leaders at the bar, in communities, in legislatures, in Congress, in government, and in the courts and in private organizations begin to learn their art: reason, restraint, skepticism, irreverence, risk assessment, courage, lucidity, incisive analysis, and consciousness of decision." He added, "These are the forms by which the humanity of the law moves into the minds of our future leaders as they prepare for action for the common good." Judge Browning demonstrated that a graduate of Montana Public Education and the University of Montana School of Law could succeed spectacularly on the national stage, leaving an indelible imprint on the judicial work of the nation. He also showed that the Montana virtues of integrity, hard work, perseverance, personal warmth, and honesty can make an impact on our world. Perhaps the best sentiment is expressed in his own words. On the occasion of his 40th year on the bench, Judge Browning was feted appropriately, and in responding, he said, "A group of very fine people have just spent over an hour thanking me, in essence, for devoting 40 years of my service, of my life to service on this court. But serving as a judge on this court is not something for which a lawyer should be thanked. On the contrary, it is a privilege, a deeply satisfying way for a lawyer to spend a life in the law. In no other activity can a lawyer participate so directly and significantly in maintaining and hopefully improving a system of rules that make organized society possible and provide the means for peacefully resolving many of our most difficult problems." I've never doubted that over all these years. I've always known that as a judge on this court, I was among the few who had been given a maximum opportunity to solve problems and make life more worthwhile in the society in which we live. I thank you and the powers that be for giving me that privilege. He closed that speech by quoting from former California Chief Justice Roger Traynor. "The courthouse is every man's castle, his fortress against tyrants of powerful government or of powerful private groups, and against mobs and brutes and scoundrels. Gold is where you find it, and the stake in it is yours. But justice you find and share with others in every man's castle, the courthouse." And at Judge Browning's memorial service, his former clerk, Judge Chen, spoke for all of us in describing the enormous pride we feel every time we walk into the San Francisco courthouse that bears his name, the James R. Browning United States Courthouse, Jim Browning's courthouse, everyone's castle. When my predecessor, Alex Kaczynski, accepted the gavel as chief judge for a 7-year term, occasion of which Judge Malloy spoke on behalf of all the district judges in the circuit, I was seated next to Judge Browning, who was then confined to a wheelchair. At the conclusion of it, he grabbed my arm forcefully and said, "I want to be here in 7 years when you raise your hand." Well, he didn't make it, and I'll be eternally sad that he didn't. But I take the lessons of his life to my heart, and I hope you will take it to your hearts as well. I want to thank you for the opportunity to honor our friend, James R. Browning from Belton, Montana, lawyer, clerk of the United States Supreme Court, chief judge of the Ninth Circuit, and co-founder and editor-in-chief of the Montana Law Review.
Thank you, Judge Thomas. He's willing to take a few questions. I believe there are microphones out there as well.
None on antitrust law, though.
Okay, there we go. Good, good. All right, good. And you can manage questions with yourself.
Is it like herding cats, or how does it work?
Well, I said at the gavel passing that very large cats. Very large cats, got pride of lions. My predecessor, Alex Kaczynski, was a man of great style and panache, and he was a good lion tamer. I said at my gavel passing, I aspire more to be a lion whisperer, but we'll see how that goes.
What do you see as the biggest challenges facing the court now in the coming years?
Certainly, we've had a significant crisis with the budgets, with the sequester, and with the government shutdown. And there are specters of those looming in the future, and those create a lot of difficulty. One of our greatest problems has been in the management of immigration cases. We started, when I joined the court, we had 1,000 immigration appeals a year, and then that went quickly up to 6,000 because of a decision made by then Attorney General Ashcroft. And to put that in perspective, there no other, maybe 2 other circuits have more than 5,000 cases total. So we were essentially assuming the work of a whole nother circuit with the surge of immigration cases. We get half of the immigration cases filed in the United States. But we've worked through those, and we have some methods of dealing with those cases fairly and efficiently, and the caseload is starting to come down. So that has been one of our great challenges. I think the challenge globally for the Ninth Circuit is how do you stay large and make sure you keep in touch with the communities, because the circuit is very efficient, but it's easy sometimes to lose touch, and we're trying to reach out in every community through the use of technology and through the local attorneys and judges there to make sure that we understand the problems that exist throughout the Ninth Circuit, make it a comfortable place in which everyone can do their best work, whether they're a solo practitioner out in Baker, Montana, or a downtown attorney in Los Angeles. And we're absolutely committed to that. And we're committed to making it easier for attorneys to practice in the Ninth Circuit by giving them better and more quick information about their cases. Right now, you can see all of our cases streamed live at the argument and also on our website. So no longer do attorneys have to go out, as Judge Malloy and I did often, to scout the panel out for a couple of days before an oral argument. You can watch them live on streaming video. And we hope to keep up those innovations. But those are some of the challenges we're facing.
You wait for the microphone.
You referred to some decisions by Judge Browning in the area of the adequacy of representation by counsel. Did he also have any opinions in the allied area that arose post-Gideon for the next decade, where the courts were so enthusiastic about appointing court-appointed counsel, they were forgetting to advise the defendant that he had the more basic constitutional right to defend himself?
Certainly. I can't recall if he had a hand in any of the Ferretta decisions, but he certainly sat on a number of Ferretta decisions, so that's where the right of self-representation. At various junctures in his career, I think I may have sat with him myself on one of those. The law was pretty well established by the time I think he hit those cases, but he certainly, once it was established, followed it and advocated it. Those are the Ferretta decisions are very as you know, they're very complicated decisions to balance the right of self-representation and the right to counsel. But he certainly, I know he dealt with a number of those cases.
I was opposed to splitting the Ninth Circuit because there's so much politics involved. But from your perspective, what are the pros and cons of splitting?
Well, it's, you know, if you're sitting in Montana, it seems pretty intuitive to split it. You say, you know, we'd like a nice, cozy circuit out in the Pacific Northwest. But the more and more that I've learned about the Ninth Circuit and the time I spent with it, it would be a tragic mistake to split it, and Montana would suffer. If we were starting circuits now, if we were going back to the chalkboard, we would have larger circuits rather than smaller circuits. They're inefficient. They duplicate services. They're very expensive on a per capita basis, more than let's say the Ninth Circuit. So from my perspective, it's managed well. And let me explain why I think Montana would be hurt, because I assume that's the impetus for part of the question. The Ninth Circuit has, as I indicated, we had a high of 16,000 cases filed each year. We have about 12,000 now, and of those, there are about 200 from Montana. The formula for funding is based on caseload. So if we were placed in a small circuit, and it's a very small number of cases that would be in the Pacific Northwest, it would have a caseload, one of the smallest caseloads in the nation, if not the smallest caseloads over a large geographic area. And that, it would just absolutely be clobbered for resources. There wouldn't be anything we could do. And we've benefited so much from association here in Montana. I think with our construction of our courthouses, with political support from other judges from different parts of the circuit and their political representatives, it's been a real advantage for Montana, and we've had a great influence. I mean, I think Judge Malloy would attest that Montana has, those of us from Montana have had a great impact on the circuit, and I think it's been healthy for the circuit. So for me, it's largely, I think if you really look at the data carefully, there's not much of an argument that should be made for splitting the Ninth Circuit. There are political arguments to be made for sure, but those arguments, even when you get down to those, they simply don't really pan out if you look at the numbers. And there's no really good way to split the circuit. The only fair way to split the circuit in terms of splitting the caseload is to divide California in half. That's the only way that makes any sense, and of course that is really unacceptable. What I think, if you're looking at splitting circuits, you should look at a circuit that is geographically coherent, that is jurisprudentially coherent, and I think if you look at the way the circuit is structured now with our common heritage, the Ninth Circuit should remain intact. I guess I didn't give any cons, did I?
Do you have any brief reflections or advice for people just about to start a legal career?
I think I really enjoyed being a lawyer, but I think a lot of people do not. And I think the practice can be wearing on people. So what you have to do is to make sure, in my opinion, you practice with honor, you practice certainly with hard work, but that you remember why you got into this profession in the first place, and to keep those values intact across a long career. If you do that, you stay true to that, and you serve your clients and not yourself, then you're going to be have had a satisfying career. I always encourage my law clerks to take on the most difficult tasks that they can, the stuff that's way over their head. And that's the way you keep challenging yourself. That's the way you become a better lawyer. And if you keep the practice of law interesting and rewarding, then it'll carry over onto your personal life as well. So I think the first thing is it's easy in the first couple of years to lose sight of all that. You're working hard, longer hours than you ever thought possible. Sometimes you're on tasks that are very boring. But if you keep putting your clients first, if you keep making sure that your values are intact, and if you're in a situation where it's a bad environment, just get out. You have to do all those things, but always have that ethical and value gut check.
I wonder if you have any observations or recommendations or suggestions about what seems to be a growing nationwide sentiment cutting across political lines and religious lines and sociological lines, namely the idea that we have been putting too many non-violent people in prison, the idea that the war on drugs was well-intended, other efforts to curtail crime were well-intended, but that had the unintended effect of putting an awful lot of non-violent people in jail, which costs us a great deal of money as taxpayers and harms the individual family and so forth.
There's a lot of interesting work being done in that area, and it's not only non-violent, but how to. I read a paper this morning about rethinking our way of dealing with violent offenders, but certainly our prisons are overcrowded. We're putting a lot of non-violent people in there. That's a question for the other two branches and not the judiciary. But we are very concerned with prisons and how they're operated, and to that end, we're organizing a prison litigation summit later this year that will bring together corrections officers, attorneys on both sides of representing prisoners and also representing the government. We're going to bring in judges together and some sociologists and talk about the problem of the prisons. Right now, and I should have added this to my list of challenges, Professor Huff's question, but fully 50% of our workload is pro se right now, and a large volume of that comes from the prisons. So what we want to do is to see if we can solve those controversies within the prison setting rather than in the courts. And how do you do that? You bring in mediators, you strengthen their internal administrative processes, and you try to see if you can really get to the root of the problem before then it spills over into the federal courts. And it's not just avoiding these problems, it's just when you see them, almost all these cases you say, this should have been resolved one way or the other in another mechanism in another time. And if you're dealing with a medical issue, for example, it's now morphed into a malpractice complaint as opposed to a treatment option at the prison. They're very challenging issues, but under the leadership of Judge Randy Smith, whom many of you know, and Judge Pyle from Arizona, we are convening the summit. It's the first of its kind. I've talked with the correctional officers involved. They're very excited about it. It's really a very good endeavor.
The reversal rate? Okay. He has that answer primed every time. What about, Judge, what about the Ninth Circuit's infamous, notorious reversal rate?
Well, it's just an urban myth. No, it really is. We were, I don't have all the figures here with me today, but we were the 4th most reverse circuit last year. We were the 6th most reverse circuit the year before that. The year before that, we were the 5th most reverse circuit. The year before that, we were the 5th most reverse circuit. The year before that, we were the 10th most reverse circuit. And the year before that, we were the 9th most reverse circuit. I have not been able to find a single year in the last 25 years or more when we were actually the most reversed circuit. Now, people say, well, percentage-wise, maybe, but if you took about case volume, maybe that's different. You say, well, then we're the most affirmed circuit, too, because they take a lot of our cases. The worst reversal rate we ever had, in my memory, was the year before I came on the court, and 1995, 1996, and we had a 95% reversal rate. You think that's pretty bad. But the Supreme Court reversed all of the cases of 6 other circuits, so we were not even in the top 5 reversed circuits that year. The fact of the matter is that really not many cases go up to the Supreme Court. About 1% of our cases, less than 1% of our cases go up there. And the Supreme Court is going to reverse, on average, about 75% of the time. They don't take cases to say, you know what, this was such a great opinion. We're going to look at this, and we just give you an attaboy because it is so terrific. We just, we weren't content to let it sit on its own because somebody sees a problem in a case. Now, there are other, the Sixth Circuit, I think, went for 3 years. They got everything reversed for a period of 3 years recently. So we're not the most reversed circuit, but nobody believes that, so I don't anticipate you will either. I mean, I actually said that once. I was at Berkeley, and there was a kid who stood up and said, you lie, So it was one of those you lie moments, but I said no. But I think, what do we take from reversal rates? For me, they're not very significant. What the Supreme Court says is very significant, and it's particularly if they're showing that they're shifting in a particular area of law, whether it's habeas, which they've done recently. They've had a major shift in antitrust law over the last 5 to 7 years. And it's very important to watch those trends, but it's not a very useful statistic. I mean, I had one case I was reversed on, or our panel was reversed on. I wrote a dissent suggesting that the Ninth Circuit should follow the Second Circuit, so I guess I technically won that one. But it wasn't, those are, we were following the law of the circuit. We would have had to follow the law of the circuit. We don't have that option, so anyway. That probably wasn't the best way to end things, but
Well, I think Chief Judge Thomas has shown that he is perhaps the worthiest successor to Chief Judge Jim Browning here in Montana. I wanted to say before we move over to the South Ballroom for a reception in honor of Chief Judge Thomas's, what's the verb for the receipt of the gavel, I suppose. Several dozen of Chief Judge Thomas's clerks and friends have gathered together and put together a scholarship, the Honorable Sidney R. Thomas Scholarship Fund, to recognize a student at the School of Law who shows the kind of academic promise and leadership potential that launched Judge Thomas on his remarkable career. And I'd just like to say thank you.
Thank you.